Let's run this by you. Diabetic Diagnosis Center is your ultra-modern diagnosis center specializing in the treatment of fibroid. And they have competent and well-trained staff who will ensure that you undergo the treatment of fibroid without any operation, all under hygienic conditions with the application of modern technology in practice. They are located at Okponglo Junction here in Accra, TUC in Kumasi. You can call them on the following numbers: 024 317 6119 or 0207 515623 or 0273327 Diabetic Diagnosis Center. We treat fibroid without any operation. Now, let's look at what we have for the morning, but let me just introduce my guests and Dr. Jinapo. Dr. Abu Jinapo, how are you?
Abu Jinapo.
Right.
Dr. Ahmed Jinapo.
Ahmed Jinapo, sorry. Dr. Ahmed Jinapo. He's a lecturer with the University of Education, Wodeba. And thanks for joining me.
Thank you, sir.
It's been a while. When was the last time you were on the show? I was not on.
Yes. I think a couple of weeks ago, but it's been a while.
Okay. And we know. Okay, so now the Electoral Commission has told political parties it will not delete the names of persons who registered as voters using National Health Insurance cards, disputing claims a recent Supreme Court ruling directed it to do so. Former PNC organizer Abu Ramadan had claimed vindication in the Supreme Court ruling, confident the decision had gone in his favor or the way he thought it should be interpreted. His lawyers also insisted that the court directed the EC to delete the names of such persons from the register. There have been a lot of brouhaha. We know this is an outcome of the IPAC meeting. IPAC is the Inter-Party Advisory Committee meeting convened by the Electoral Commission, and then at that very meeting it was said that a number of things were discussed concerning politics, the election, and the political spectrum. What do you make of this very decision, Dr. Ahmed Jinapo?
Well, let me say good morning to your cherished viewers.
Good morning. You don't have a constituency.
I do.
Yet. So you don't mention, I mean the MPs, they mention.
Oh, okay, they do, right?
My good, they like mentioning
my constituency is Yapiko Sogo, but I think ideally my constituency would be the University of Education, but of course. Right. Roland, you say it's an interesting and quite complicated issue to address.
Like yes, the last 12 hours, we've all been in a confused state, right?
Yes, and it's interesting and complicated because, number one, we are looking at two things. We are looking at the law, and not just the law, but the law as it should be interpreted by the highest body of this country, the Supreme Court. And I'm tempted to believe that the ruling was chaired by the Chief Justice. The ruling was chaired by the Chief Justice. And I say this because this issue, like it or hate it, has traveled to the last or the apex of our judicial system, which is the Supreme Court. And today, we are still in a state of confusion because based on that ruling, we still do not know what the ruling means. We don't. As I said, it has a political dimension and a legal dimension, and I'm looking at the legal dimension. I'm not a lawyer, but I try to understand and interpret it as it is from the layman's perspective. And it looks as if, even from the layman's perspective, we still have confusion surrounding this whole thing. So the question is, from what I heard, and you see, the confusion is even more ingrained in the sense that, Roland, if you remember, when the ruling was given and we had the reportage from the court, it looks as if the reportage from the court and posts the coming into being of the writing or the ruling itself, there seemed to be a little bit of a difference. But I think the bone of contention.
Have you read the ruling?
No, I haven't, unfortunately.
So it means that all the information all you analysts are giving is based on media interpretations and
not interpretations necessarily, but I mean it's based on the information that we get through the means that we normally get information, and it's very simple. I think the contention here has to do with the NHI card. That is the whole thing, because the Supreme Court ordered that, based on what I heard, it ordered that, one, the EC should take steps to delete names of people who have passed on. I don't think that is any issue of contention. Two, people who registered with the NHI card, their name should be expunged, but should be given opportunity to what? To register again. That is what was banded around in the public domain. And now I get to the political angle of it. The political angle of it is such that it makes it more complicated because of the entrenched positions taken by the two major political parties, the NDC and the MPP. If you observe,
now the PNC has been towing the line of the commission. Seem to agree with the Electoral Commission as well.
I don't think the Electoral Commission has a position and should have a position.
So it doesn't have a position.
I don't. For now, it does. No, for now, it does.
It's giving its position as to what it thinks the Supreme Court says it should do.
That is it.
That's its position.
And it's subject, I mean, whatever the Supreme Court says, depending on which side that you swing to, determines how you see it to be. But you see, the point is this. Let's look at it. Let's even move outside the remit of the legality or the law and come into common sense. The common sense is this, Roland. It's important to state, and I'm not trying to more or less refute the ruling by the Supreme Court. I'm just giving my position as an ordinary Ghanaian and how I see it. You see, it's important to note that prior to 2012, people who registered with the NHI card or National Health Insurance card, they did not commit any crime. And they did not commit any crime in the sense that, as at that time, the law did not bar them from using that card. As a matter of fact.
So the law only now bars them?
No, no, now I'm talking of previously. As a matter of fact, if I happen to go and register, and going to register, I happen to have had a National Health Insurance card and a driver's license and a passport, and during the process of registering, I dip my hand into my wallet, and the National Health Insurance card happens to come out first. There's nothing that you understand.
Because it was acceptable.
It was acceptable by them. So the point that I'm trying to make is that today, if you look at the nature of our registration system, especially with specific reference to what the limited registration that took place, what it says is that you are supposed to register with a driver's license, a passport, an old voter ID card.
Today?
No, the last one.
Okay.
The last one.
This one, you can't register with a driver's ID.
You can register with a driver's license.
It's only the passport.
The passport and the what? And two people coming to testify.
You can verify.
You understand what I'm saying? Two people coming to testify. My argument is that today, if we are saying that these guys who are using the NHI card should be expunged from the voters register, but should be given the opportunity to register. Let's say if they don't have a passport, the only way that they are going to be allowed to register is if two people come to attest to the fact that, look, they are qualified to register. And it will interest you to know that as of the time that they were doing this last registration, these guys who are holding the National Health Insurance
may not be having passport.
No, even then, they could attest. They could attest to people to register because by then they already have a voter's ID card. You understand what I'm saying?
I get your point.
Yeah, they have a voter's ID card.
You're saying a lot of misnomer.
So what I'm saying is that at the end of the day, I think this particular issue provides us an opportunity to look at how we can come up with long-term plans to address this issue.
Well, true. We're talking long-term, but we also need to speak to the short-term.
I agree.
Because we're just some few months away to the election. I have on the line Lawyer Yawopong. A very good morning to you, Lawyer Yawopong. First, what did you make of what the outcome of the ruling for, the Ramadan Mafu case was, and vis-a-vis what the interpretation is or the position of the EC is as to how he hopes to implement the outcome of that very decision by the court?
Okay. Thank you very much. Good morning.
Morning, sir.
Well, for my reading of the Supreme Court decision, I hold the view that the court clearly stated that the register is bloated, it is not credible, it is not reasonably credible and accurate. Two reasons. One, that names of persons who registered with the National Insurance card, those names made or has made the register not reasonably credible, accurate. Then also, names of deceased persons on the register also do not make the register reasonably accurate and credible, and also names of minors. Then the court made an order upon the EC to immediately take steps to delete these names. The court also said that those whose names are deleted must be given opportunity, proof, and to be re-registered. In my view, in respect of these three categories of people, it is only those who registered with the National Insurance Card who should be given the opportunity to prove that they are otherwise qualified to register. Obviously not the deceased or dead person, and also not minors. And the view I hold is that to give them opportunity means that their names should be published, fair opportunity giving them go to various, if you like, branches or units of the UC, prove that they did not use the NHIS card, and if they are unable to satisfy them with the answer, their name should be deleted.
Yeah.
And an opportunity given them to be registered. And this is the position that my own good friend, Mr. Hussein, also shares, even though he varies a bit that it should be deleted first, even before then further opportunity giving them to be registered if they prove to be eligible for registration. And so that is what I hold. And I think the EC, contrary to what I have seen in some of the newspapers today, are not saying that those names will not be deleted, even if it is proven that they use the NHIS card and that they are not Ghanaians or otherwise not qualified. What they are saying is that, in their view, their understanding is that their own UCI, 91 or so, they will only delete those names if there is a challenge. The challenge is brought before a court magistrate. The magistrate makes the order for it, the name to be deleted.
Okay.
But then, if that is the case, the Supreme Court further ordered that those people whose names are deleted should be given opportunity to be voted will not be in line with that, or if that is the provision, that provision will not be in line with the Supreme Court decision. Because once the person's name is deleted, it means the person is not qualified to be registered. And it also means that there are sanctions, this 5 years or so, within which you will not be qualified to vote in an election. That constitution is also makes it clear.
That's very
So
interesting.
Yes.
That's very interesting, especially if that is also the explanation you're giving to it. But do you think the position of the EC is as a result of how perhaps the ruling was couched? And so in the interpretation of the Supreme Court, in itself has left the whole process or its ruling in itself to very much to varying interpretations by depend on which side of the divide you are before.
Well, I'm not sure of what you mean by divide. I don't belong to any divide.
No, not necessarily. No, I'm not talking about you.
No, never mind. But I think that there's no divide. The point is that I don't see any ambiguity in the Supreme Court decision. The clear orders are made. Take immediate steps to delete the name. And so you don't read that in isolation to two. And the name, any person whose name is deleted from the register of voters by the Electoral Commission, pursuant to Order A above, to giving the opportunity to register under the law. It is referring to those who use the NHIS card, which the court has declared to be unconstitutional. The process of deleting the name is what people are infusing some disagreement into. And I say that, as far as I'm concerned, when the court said that this approach enables us to do justice in a manner that preserves the rule of law, then we think that any person whose registration is affected by the decision in the Abu Ramadan case be given the opportunity to go through the process of registration to establish its eligibility or otherwise, in order that the appropriate remedies provided be applied. And the court says that it should be deleted in accordance with law. The Supreme Court decision is quite quite clear on this matter, and I'm saying that what people are disagreeing is how the deleting should be done. I don't think the EC themselves, contrary to what others are reporting, have said categorically that even if it is proven that somebody was not entitled or qualified or eligible to be registered, had his name entered on the register, and even that is proven, and the court makes an order, they are not going to do it. That is not what I understand them to be saying.
Okay. Well, thank you very much. I think I need to come to your law school, wherever you teach, so that I can...
Come to Central.
Okay, I will. I will. Thank you very much, Lawyer Yao Pong there. And very interesting point there. Your own position on what the EC has said in its statement and the varying argument you've had following the last 12 hours, the announcement by the Electoral Commission.
Good morning to your viewers.
Good morning, Richard.
I have a bit of some inside knowledge. When there was an IPAC meeting and some decisions were taken, and the IPAC insisted that the EC make its position public within the shortest possible time. I think they were given 24 hours to do that. Information I picked from the IPAC meeting is that, contrary to what Lawyer Yao Pong was saying, they were very categorical that they were not going to expunge the names. If you have any issue, you bring a challenge. Okay, and then based on the challenge, you will go through the due process. Now, this is a process that the committee that the Electoral Commission itself set up. Okay, the Justice Crab Committee lambasted and just dismissed. Because
it doesn't mean that it's not
no
law.
you see
Because
no you see
those
when
are
you have
processes, regulations.
no, you see when you have a law
process
that
by which you
laws are made for people, and so if your own committee tells you that
you can't misapply the law.
Hold on. When you have a provision that is not workable, it's not tenable, okay, there's no point. Now, I am supposed to come and prove that ABCD has died, and so take the person's name from the register. How is that my responsibility? You see, it makes the EC very lazy, because they have absolutely no responsibility to do anything. They don't care. And so until somebody comes and challenges, and you're talking of even obituaries, I should bring obituary as proof.
So
Roland Walker, do you know how many times I would have killed you through obituary then? Because all I need to do is print out an obituary, and it's very easily done on the internet cafe, and take it to the EC as proof that take this man's name off. All I need to do is probably go and paste it in some innocuous part of town and ask them to go and see it as evidence. And so let's be very careful. The responsibility to register people, okay? The responsibility to ensure free and fair elections, the responsibility to ensure a credible register is the sole responsibility, sole job of the Electoral Commission. So when you begin to renege and push that responsibility on we the voters, I think it is most unfair, and it will not wash. Now, you know why the EC is in this quagmire?
I don't know.
They have put themselves in this situation. In one breath, they go tell the commission that they have the Form 1As, okay, that contain the data showing that NHIS cards people registered with them, they have the records, okay? And then in another breath, in having a negotiation and talk with the legal team that sued the Electoral Commission, they make it clear that it is virtually impossible. And the truth of it is that the EC is in this current situation unable to fish out the names. You know why? An estimated 4 million people registered with the NHIS card. They are not compartmentalized. So you cannot go to the district office.
Which means what? Is that an IT term?
No. It's very simple. It is not like you go to the EC office at the district level and you have all those who registered with NHIS.
Database.
Yes, and have all those who have registered with NHIS cards lying in one folder, and then you have those with driver's license in another folder. It's not like that. It's all bulked together.
So you mean you
and
have
they
to
looking sift through. They are looking at data of over 50 million people, records that have been boxed together that have to be looked through one after the other. So there is a difficulty in doing this within the stipulated time.
And you think that's why the EC has
And that is why they are, you see,
but like Pons, if you get his interpretation very right, or his explanation, he says that the EC statement really, and we're working with a statement, we're not working with an IPAC hearsay that you know.
Yes.
That, well, from what they say, according to what he's seen in the statement, it doesn't give any indication that the EC is saying it will not delete names. It just says that within the regulation, ways by which you need to do the deletion of names. So even though the Supreme Court says delete names, they are willing to delete, but there are processes inherent in law.
No.
Which mandates it to delete. So the Supreme Court can give you a ruling, go ahead and delete.
Yeah.
But when you come in reality, there are processes by which you can do deletion. It's not the Supreme Court who gives you an indication as to how you have to delete.
That is
the how. The Supreme Court says go and delete, but the how you delete is stipulated in law.
And that is engaging in semantics.
Oh, really?
Seriously.
All right.
Now, the Supreme Court says that delete and give them opportunity. So if I'm deleting and giving the people an opportunity, what is it that I should now come and challenge that this person registered with an NHIS card? Why will I go through that laborious process, get the person's name removed, and then put back? What is that about? I don't.
Roland, I think very quickly. Number one, at a point in time, as has been reiterated by Richard, during the Supreme Court adjudication over this whole issue, there was a question posed to the Electoral Commission as to whether they had data of people who registered with what did you call it?
NHIS.
The NHIS card. And my understanding is that the response was a yes. And I do not think the Supreme Court would have posed that question if it wasn't meant for something. So I'm tempted to believe that based on that question and response, it's more or less motivated the Supreme Court to say that, look, if you have the data, then it should be easy for you to delete it. That's it. If you look at the posture and the listing, and you listen to the Electoral Commission, based on, especially the response that came post the verdict, that they had already initiated processes to deal with this issue. What you can deduce is that, look, the Electoral Commission, by its own ways and means, have certain mechanisms for doing this. One of them being during the exhibition process. But you see, at the end of the day, my argument is this. For every Ghanaian and for every political party or institution that is interested in a successful election, we need a credible voters register. There's no doubt about it.
Yeah.
But in as much as we need a credible voters register, I don't think it would be fair on the part of the various institutions to disenfranchise any body who is qualified to vote. That said, I think once we think through this, and I heard from Mr. Ramadan that he'll be going back to the court. I think that is the best way to go about it. He goes back to the court. For the court, if they have to give a further ruling to clarify issues, that needs to be done. But I think it's also important for people to understand that, look, at the end of the day, whether you like it or hate it, the Supreme Court is a policy-making institution.
It's a lawmaking.
It's a law, but it's also a policy-making institution. In fact, indeed, I've heard some people critique the Supreme Court in their ruling, one of them being Professor Sari, that the ruling that
the
was
recent one.
Yeah, the recent ruling.
It's a recipe for chaos, he said.
Well, I don't want to use that word, but what he was saying was that it was quite vague, in the sense that it tried to satisfy both parts. And that is why I make reference to the fact
that because now, according to the statement of the EC,
that is why I make the point that, look, the Supreme Court is a policy-making institution. At the end of the day, in as much as the Supreme Court always interprets the law to the latter, it also takes into consideration the public good.
Okay.
You understand what I'm saying? How does this affect the public, or how does it affect society? So my point is that, look, I will encourage Mr. Abu Ramadan to what? To test the court or the law.
So they should go back.
I don't have a problem with that. I think I will encourage him to do that. But at the end of the day, I think as a people, we also have to start thinking about how these things can be addressed in the long term. In the short term, yes, Mr. Ramadan.
Long term, what do you suggest?
In the long term, my brother, let's look at it this way. Almost every year we have a problem with our voters register.
So we need to have...
Indeed, last year, because of the voters register problem, we had something called verification and biometric registration. You remember?
You mean the last election period?
No, the last election we had biometric registration and
Which
biometric
even created problems in the
So
election
my
day.
argument was that if we had biometric registration and your biometric data was taken, if you were not verified, there was no way that you could vote. You understand what I'm saying? So this issue of foreigners should have been a thing of the past, because your biometric data should have been taken. Today, we started the election somewhere in 1992.
But we have biometric data of foreigners taken. That's how come we're raising concerns. Because it means that you'll be authenticated.
I agreed.
And it won't differentiate whether you're foreign or not. Your biometric details, that is whether you're a Moshi or from Mali.
No, if a Moshi, you can't say Moshi is not a Ghanaian. A Moshi is a Ghanaian.
Okay.
We have Fulani people who are Ghanaian. I mean, we have Wangaras who are Ghanaians.
All right.
By our laws.
So here goes the argument.
No. By our laws, your citizenship is based on birth. My dad's Fulani men, their children are Gonja. They are Fulani people, but they are Ghanaians because they were born.
Or some other. We have to.
Yeah, Beth or some other. But let me make this point very quick. Today, 26 years, we are still fighting over this thing. Why can't we start just today, Roland, and say, look, every child born today, we are going to give the guy a social security number or a number of some sort, and biometrically what?
You're talking about some level of identification.
Identification. That is the whole problem.
For which we can't verify from a database. If we want
that is it. It's as simple as that. Look, do you know that this is our current ID card that we use, the one that we registered? I quite remember recently I went to the bank to cash money. I gave them my card, and I was surprised that the data, like not the whole data, the screen,
it's been synchronized.
It's been synchronized, and it came on the screen. So the lady was watching me like.
So it's an ID.
No, it's an ID, and I was so surprised. The point that I'm trying to make is that even at the end of the day, if we can use this card, just this card, as a basis of national identification, I think we'll get somewhere. If not, we will still go round, and it will be merry-go-round.
All right, so Richard,
Richard,
I know you wanted to bring. Now, for all the things that we're saying, the Supreme Court also said, go and delete names, because even though the last time in that very ruling for Abu Ramadan, it said it doesn't take retrospect, he also said it doesn't automatically render them void. That's what the Supreme Court said in its ruling. And such position, according to the Supreme Court, would have and it continue would have the effect of disenfranchising the persons affected. That's what the Supreme Court said. Such registration should only be deleted by means of processes established under the law.
Okay.
I'm reading this because the Supreme Court says go and delete the names. But it also states in its same ruling says such registrations should only be deleted by means of processes established under the law. So
what is that?
It says Ghana Immigration Service deport this person, but the person has to be flight worthy before the person can be deported. That's a rule. You can't take the person through the air unless the person is a witch. Now it says go and delete the names, but the laws that governs or the Electoral Commission operates with stipulates ways by which you can delete. And the Supreme Court has stated in its ruling that we say that those people registered with NHIA, so go and delete them. Give them an opportunity to register again. But before you do the deletion, make sure that it's within the confines of the law.
Of the existing law.
You see,
and the law
Roland,
stipulates ways by which you need to delete somebody.
I get your question. You know something? That is why Professor Azan's position is quite, let me say, a sensible position. Why? You asking, because you look at the ruling and the processes established. they are in contradiction of each other.
No, I think it's a contradiction. I'm sure the Supreme Court, because Laopon says there's no ambiguity in the ruling of the Supreme Court.
Hold on.
It's our lay interpretation.
Hold on, can I make the point?
Please make the point.
The point is this. If the EC's understanding of the processes established under the law is for me to go and challenge somebody's status, that this person registered with NHI, and in the first place, I will not be able to do it. So even what the EC
do it? So the EC has to go through its
because
system.
Please, how do I know that Roland, you registered with an NHI card?
But you are saying that people registered with NHI card. How did you know?
Oh, please. Let's be serious here. Let's get serious here. The EC, in their own admissions before the Supreme Court, said they had registered people, an estimated 4 million of them. So this is from them, and they have indicated they have the data. In going into court the second time with Abu Ramadan, they have indicated they have the data. But in private, they say that the data is so huge and mumbled up that they will not be able to sift them out. So the registration is done. But I'm saying that the only person who has the evidence is the EC. So this process of you then exhibiting it for me to then come and challenge is neither here nor there. And secondly, if the Supreme Court meant that they should go through that process, then why would they say that? Take their names off and validate them again, or give them an opportunity.
But then how do you also interpret what the Supreme Court says should be done by means of the processes as established under the law?
You see, this is where we have a problem.
With what? The ruling of the court?
This is where, you see, Ghanaians, unfortunately, we are so hypocritical in our ways of doing things. And we normally bring these things upon ourselves. If I remember, the MPP initially was asking for a new register altogether. Then this process of having a committee came and sat down, and all the processes went through. The committee came up with recommendations. The MPP has since shifted its position. And if you read the recommendations of that committee, in there is that they should validate, because the processes so far established
the committee's explanations go contrary to what you are saying here.
Oh, please, have you read the pages?
One member of the committee was here.
You see, he's
the chairman of the Peace Council as well.
Is he the chairman of the committee?
He's a member of the five. He's one of the five.
Is he the chairman of the committee? At least I am lucid, and so if I take a paper and I read it, the common sense meaning of it I'm able to make. So that if it says that the process of exhibiting data or names for people to come and challenge is not a very good way of having a credible register, they are telling you that process is flawed. And then they tell you that you should have a way of validating or making people come and confirm. Okay? Now, what is happening is, and this is the whole point I'm driving at, the MPP has then shifted to this position that, okay, let us all go and validate. But you see, because the EC has already taken an entrenched position and seems to be enforcing or wanting a particular position satisfied.
Why do we keep saying the EC has taken an entrenched position?
Yes.
The EC is the only legal body that's supposed to interpret the laws the way it deems fit.
The EC has no right under the law to interpret the law.
Unless if you feel there's a problem, just like Abu Ramadan and Co thought there was a problem, they went to the Supreme Court.
I'm saying that they have no right to interpret any law. The EC does not interpret laws. They work with what the law says. Yes. So that if I have
their
a
understanding
difficulty,
what the law says,
and that's why I'm saying,
and it's by understanding of what the ruling said. That's
the EC's own committee then recommends this process, but then MPP comes and says that let's validate.
Well, Richard,
and all of a sudden it looks like the whole country is like, no, the validation is not the way. But you see, the situation in which the EC finds itself right now, I can tell you on my life that validation is the only way out, because of the numbers involved and the difficulty in sifting them out. If you told everyone from 1st of August to 31st August, we are opening the register and we are displaying them in your constituencies, wherever you registered, go with a credible identification, go and confirm your name. Else, beyond that period, we'll take out if you haven't done that.
But why should we do that?
Why should we do that?
Somebody could have traveled.
Why? Yes.
But why should we do that?
Roland, under the same provision.
Let's look at this. After
the same provision, you can make
now. Let's listen to
for
Nana.
Those who have traveled.
You know Nana Santibidito.
Yes.
Okay, he's a legal practitioner for Abu Ramadan and Co. He spoke after that very ruling. Let's watch him. And then also on Newsfile, we had Alhaji Nusa Hussaini. He's a lawyer as well, but also a member of parliament and a minister.
I thought I had something slightly different in court. So I'm wondering whether on the order A, some words have dropped. And I've consulted other people who are in court who also appear to have heard what I've heard. But we know what to do about that. So we'll take the required steps. But we'll have to go back to the court. As I'm saying, I seem to remember I heard something quite different.
Okay.
And that is why I don't know if words have dropped. We'll find that out. And if the court can always clarify. So, and remember also that, you know, whether there is existing law or not, the EC can in fact also promulgate a new instrument just on this to deal with what the court is saying if required. So I mean, if we want to do something, we can do something.
Okay. I have a different view of the ruling of the Supreme Court. I think basically it appears to me that the ruling is so clear. It's so clear.
So clear to the effect that?
The effect that the law, the primary basic law says that every Ghanaian of sound mind ought to be registered.
Right.
The subsidiary law sets out the criteria for determining who a Ghanaian citizen is.
That's so.
And then proof of citizenship. Now somehow, when the register was being compiled, some people used the NHIA cards as proof of citizenship to register. In an earlier decision of the court said those cards cannot otherwise be used to prove the citizenship of a Ghanaian to register to be on the register. That being so, those names or the names of people who use those cards to get onto the register ought to be deleted. Because that clearly doesn't establish them. I mean, it's not one of the criteria for establishing citizenship. Okay?
Right.
So they ought to be deleted. Simple. Secondly, the names of people who otherwise were qualified to be on the register but who have been deceased ought not to continue to be on the register. And so those names have to be deleted. Now, what the Electoral Commission ought to do is to set out an implementation strategy, because the court further said that those people cannot and should not be disenfranchised by reason of the fact that they use HIA cards to get onto the register. That the Electoral
Commission understanding that is different from what the AG seems to understand and what the Commission seems to understand. Your understanding is in accord with the understanding of the plaintiffs, that those who use NHS cards were not identified as citizens, and to that effect, their names ought to be deleted.
Simple.
But upon deleting, they ought to be afforded the opportunity
to register. Yes, that's what the court is saying.
Very interesting comments there. But it seems that there's no ambiguity.
Well, I think the intention basically has to do with the phrase, no, not how the deletion, the phrase based on the existing laws. That is where the contention is, because at the end of the day,
established laws, yes.
At the end of the day, I think there's no ambiguity on the issue of those who registered with NHI card and those who are dead, their names should be expunged. And I think the ruling goes further. When it comes to those with the NHI card, they should be given the opportunity to register. As to how the names will be expunged is what is the contention. For people like Abu Ramadan and most importantly the NPP, they want a situation whereby these people who registered with NHI card should be communicated to that, look, you're registered with NHI card. This exercise is going to take place. and you should come and more or less validate.
So if the person doesn't come, the person is deleted.
The person doesn't come. But you see, my worry and the problem that I have.
The person can go to court. You deleted by name.
Yeah, you deleted my name because you did not give me the opportunity to register. You understand what I'm saying? Because the law is
they can delay the electoral
process. The law is very explicit that look, delete their names or get their names out, but give them the opportunity to what? To register. So if you delete their names without giving them the opportunity to register, you flouted the law. But you see, this is where I have a problem. And that is where I think the ruling itself is a little bit confused. Because I don't know, I didn't listen to proceedings, but from what I heard, the Supreme Court asked the Electoral Commission unequivocally that do you have data of those who registered with NHI card.
Well, Richard
and the Supreme Court said, the Electoral Commission said yes.
You are 4 million.
I don't know whether they said 4 million. They said they are 4 million. I don't think the Supreme Court would ask that question just in passing. Of course, they ask so many questions. But you see, at the end of the day, as I said, look, I would once again encourage any Ghanaian, be it an MPP member, an NDC member, or Abu Ramadan and Nimakun, if they think, look, something is not done right, they should go back to court. You understand what I'm saying? I think at the end of the day, if there are people whose names are in the register and they are not supposed to be there, the names needs to be what? The names needs to be removed. Beyond that, if people are qualified by being citizens of this country and are supposed to register and to vote, they should be given the opportunity to what? To vote.
Okay.
Because I mean, for us Ghanaians, we want a credible elections, and that should be the focus of all this discussion that we are having.
And speaking of joy, from Abu Ramadan expressed some anger at the reaction of the EC and said that they are going to raise an issue with all the 7 commissioners of
and to cite them for contempt of court. I don't know if it lies.
A member of Parliament for Sunyani is Kwesi Ameyatreme, saying that the Ghana needs to consider changing the non-partisan status of district assemblies in the country. We know that we've had problems with approving presiding members for various assemblies within the last few months.
Yes,
do we need to politicize?
Before we get there, I think it's within the purview of Abu and Nimakun to go back, and I think bringing contempt charges against the Electoral Commission is a viable option, but I think they should seek specific orders from the court as to what exactly the EC should do, because they've left that area, it's a bit grey, and the EC is therefore taking up that responsibility of interpreting the laws, and that is not its remit. Look, let's stop once again being hypocritical as a people. If you go to the district assembly, the elections there are highly partisan.
Really?
Highly partisan. I can tell you, the political parties are very active on the ground. If you heard Asiedu Nketia, he says that your numbers in the district assembly elections or on the assembly is a litmus test of your popularity and your chances of winning the general elections. Yes, this was before that election took place.
Means what?
Means that
how popular?
So how will you as a political party know your numbers in the assembly if you were not actively part, or if the candidates were not identifying themselves with political parties?
Party A or Party B?
Yes, we all know it. Let's stop being the ostriches and burying our heads, because you know what? When it gets there, the parties meet, they decide who they are going to sponsor and not sponsor, who they are giving what, who should step down, and who will best serve their interests. And it is done, the calculations are done, and they actively go out there and campaign for the person.
You talk like sometimes you've been part of those meetings.
Oh, no, I am aware of it. Yeah. I am aware of it. You are there, your assemblyman calls you, he wants something to go and
assemblyman who's aligned to you.
I'm saying that your assemblyman calls you, wanting something to go for the elections. And so you automatically know that, okay, this person,
or even
yes, and that is it. It's ongoing, and let's stop doing it. At least I am aware Nana Addo Akufo-Addo and the MPP have taken a stance that, look, let's make this thing partisan. Let it go out there. People should go and campaign.
Wow.
Okay? And then be voted on merit.
All right.
And then, just like the municipal, what do we call it, the parliamentary elections, let's have it that way.
Okay.
And then people know where they belong to. And for me, that will also bring some quality to bear at that level, because for now, we just take people on like that. But if there's competition and it is clear, and the parties are behind it, we'll get
Dr. Jenapa, it will engender competition, but I'm thinking it will make it more expensive, too partisan.
Well, I think, first of all, the framers of our constitution, I mean, thought through the benefits of as the process exists now in terms of our developmental aspiration. And they thought it wise that, look, if we want to make it partisan, it's going to affect our development. And I'm tempted to believe that there's credence to that, I mean, mindset. If you remember recently, I think, is it Kieme? There was a fist-off between the two major political parties at the assembly because they couldn't come to agreement as to who should become the
because all of them were A and B.
Listen, Roland, the fact of the matter
you couldn't get a two-thirds majority.
It's still hanging.
In the
so you can imagine what happens when that, I mean, we have such a situation. But you see, the point is this: as a country, we had the opportunity to more or less embark on this trajectory. If you remember, before Kufuor came into power, Kufuor did say that he wanted to make the district assemblies, what did they call
partisan.
it? Especially, not partisan necessarily, but the DCs, to go through elections.
Yes,
to go through elections.
That promise never.
But it never worked because of the reality. When he came into power, he realized that, look, if you haven't had the opportunity of being in that position of making that determination. At least, what's his name? Kufuor had the opportunity of being on that on that seat. You understand? And being on that seat, he became a realist. He said, "Look, it's not possible." My argument is this: I think when we are talking of the politicization of the district assembly, we should be very careful by taking cue from what goes on even at the national level. Look, it is something that we need to think through it. If we think that it's plausible, let's go for it. If we think that it's going to be beneficial to us as a people, then I think we adopt it.
Dr. Ahmed Jinapor is a lecturer, and thanks for joining me this morning. And also Richard Nyama, a member of the MPP's communication team. Thanks for joining me, Richard. We need to meet at T Havana.
Oh, please. I'm tired of hearing it.
We'll take some kebab and some palm wine and then some beer and see how it goes. He doesn't drink, right, really. We're taking a break. When we come back, we'll have entertainment. Do stay on.